we're going to look at the Payment Services Directive 2, the Package Travel Directive number 2, PCI Compliance, and we're going to finish up this part of the regulatory update looking at some aspects of GDPR and cybersecurity risk. I suppose what's certainly striking about this list of measures is the fact that they're being rolled out in 2018, and it has resulted in 2018 being referred to as somewhat of a tsunami of a year in terms of regulation. But I think it's very important for businesses to try to not be overwhelmed, and I think you'll be somewhat reassured as we go through the material today that in fact in many cases it's not necessarily that you're starting afresh, but in fact that in many instances you're already quite compliant and working towards a lot of the obligations in some of the measures, and it's just really more a case of uplifting your current practices. So without further ado, we'll have a look at the Payment Services Directive 2. And I suppose in a nutshell, the Payment Services Directive is basically prohibiting credit card fees from the 13th of January 2018. And a little bit of background in relation to this prohibition is that in 2015, the interchange fee regulation came into place, and that basically capped interchange fees at 0.3%. And interchange fees form a significant proportion of merchant service charges, and so it is expected that there will be a significant reduction, or there should already be a significant reduction in the level of the MSC charges that traders are paying. And also, insofar as an argument for surcharging credit card payments was the variations in the charges being levied and the difficulty that presented for traders to establish a kind of an average price that they could, or an average cost that they could apportion towards their credit card charges. It's now perceived that those charges will be much more predictable, and accordingly that it's appropriate that they should be absorbed into a pricing in a similar manner to other overheads. So as a consequence of the Payment Services Directive 2, retailers are no longer permitted to levy charges. There are some exclusions, however, from the prohibitions. So business cards, American Express cards, and Diners Club cards are not caught within the scope of the prohibition. So it's important that businesses think about how they're going to recover this overhead next year. And I suppose the options are that perhaps you may consider, though I don't see it as being realistic, absorbing the charge, or looking where you're creating the lead price at increasing that lead price. Or an alternative possibility to consider would be looking at applying a booking fee, or if you already apply a booking fee, that you would uplift that fee to incorporate the charges, but that must be applied across the board. The directive also makes provision for what's referred to as steering, and retailers are permitted to steer consumers away to an alternative, less costly payment method. For example, it may be that you have a booking fee or a lead-in price, and that you offer a discount in circumstances where consumers pay by a less costly means. I have to say I've struggled with this provision in the directive, because to a certain extent it seems that it's somewhat contrary to the spirit of the Payment Services Directive, but in any case certainly that's the consensus amongst commentators, that it is possible to adopt a policy of steering consumers away from more costly payment methods. So suffice it to say, this is coming in next year. Businesses have 3 months to plan and think about how they're going to absorb these charges. And when we have our panel discussion a little later on, I'm going to be talking particularly to Tom and to find out what his business has been doing and thinking about responding to the changes. Okay, so that's as much as there is to say in relation to Payment Services Directive. Important to start thinking about it and to think what plans you're going to put in place. The next topic that I'm going to cover is the Package Travel Directive. And as hopefully most of you know, this directive will be coming into force on the 1st of January 2018. It's a Europe-wide measure. And businesses are afforded a further 6 months until the 1st of June 2018, within which to adopt their practices and render them compliant with the requirements of the directive. I'm conscious that we're under very tight time constraints today, and this is very much a whistle-stop tour of the most important pieces of the directive. And what we're going to cover is we're going to look at the scope of the directive, what comes within the scope of the directive and what falls outside of it. We're going to have a look at the definition of a package. We're going to have a look at what the term linked travel arrangements mean. We're also going to have a look at the provisions in the directive that deal with financial security. And finally, I'm going to just take you through some of the other key changes that are being brought about as a consequence of the new directive. So moving along to scope, and basically what scope means is it is looking at what falls within the remit of the directive and that which falls outside of the remit of the directive. And there are 3 categories of travel arrangements that fall outside of the scope of the directive. 2 of them will not be particularly new, they're very similar to the existing directive. In the first instance, travel arrangements that are less than 24 hours, unless they include accommodation overnight, fall outside of the scope of the directive. And secondly, travel arrangements, be they linked travel arrangements or packages that are organised, that are on a non-for-profit basis, that are made available or offered to a limited group and which are offered or sold on not more than an occasional basis. So this is very much along the lines of the occasional organiser that currently exists under the current directive. However, there is one significant change in terms, or clarification in terms of the scope, and that is that business travel, it's explicitly stated, will fall outside of the scope of the directive. But it will only fall outside of the scope of the directive provided that a trader has in place a general agreement with their customer, their business customer, for the arrangement of business travel. So it's not that you can just go ahead and determine that all of your business clients fall outside of the scope of the directive. They will only do so on the basis that you have a general agreement in place with your corporate clients. But it is certainly a very helpful clarification, and one that didn't exist in the previous directive. And it's certainly helpful for those companies involved in business travel. Okay, so moving along from the scope of the directive, we're going to have a look at what are the types of travel arrangements that are packages for the purposes of the directive. And what has happened is that really the directive has incorporated various court rulings and different changes in the manner in which travel services are distributed, and tried to distill them and reflect these definitions as in the directive and bring it more up to date. So we've got an expanded definition of a package. And there are essentially 6 different types of packages now in the directive. The first type of package is where you combine and sell 2 or more travel services under a single contract. That's very much the traditional package as we all know it. The second type of travel services or travel arrangements that now fall squarely within the definition of a package is where the traveller selects before agreeing to pay at a single point of sale, where they select their travel arrangements and they agree to purchase them at a single point of sale. Those type of travel arrangements are now clearly packages, and that's responding to the concept of dynamic packages. So it's clearly setting out that these types of packages are caught within the definition of a package. And then the third type of travel arrangements that comes within the definition of a package is where those travel arrangements that are offered, sold or charged at an inclusive or total price. So in essence, a single payment equals a package. And again, this particular category of travel arrangements is encapsulating, I suppose, some of the litigation that happened in the UK about 5 or 6 years ago regarding the distinction between a total price and an inclusive price. Now, albeit that litigation related to the ATAA scheme and the definition of a package for the purposes of the ATAA, it certainly was something that didn't escape the notice of the Commission when they were looking to revisit the definition of the package for the new Package Travel Directive. Then the fourth type of travel arrangement that's covered by the directive is packages that are travel arrangements that are advertised or sold under the term package or under a similar term. So, for example, if you use the term all-inclusive or an all-in arrangement or a combined deal, something that creates the sense that the consumer believes and expects that they're purchasing a package, then that will come within the definition of a package for the purposes of the directive. The fifth type of travel arrangement that is caught by the definition, and it's not one that we're particularly, I have to say I've never come across it in the Irish market. It's known as a shopping basket, where one selects various components, puts them into a basket and then purchases at some kind of a later stage. It's one that I think is popular in Switzerland and Austria. But in essence, that type of bundling of travel services will also constitute a package. And then finally, the sixth type of travel arrangement that will be caught is what is referred to as click-throughs. And these are travel services where they are purchased from separate companies through linked online booking purchases, where the traveller's name, payment details and email addresses are transmitted from the first travel company to the second, and a contract within the latter is concluded within 24 hours. And I thought it was important to put the full text up on the screen, because it illustrates really that, albeit that it was intended that this definition would capture click-throughs where a consumer buys a flight and then perhaps gets an on-screen confirmation, and on the confirmation there's a link inviting them to book an accommodation website. And whilst the definition was intended to capture those arrangements, I think it's evident that it's very easy to avoid the being caught as a package. For example, you have to be caught as a click-through package, you've got to ensure that you've got the traveller's name, payment details and email address. Again, my experience is that it's very rare that the payment details will be transferred from Trader 1 to Trader 2. And certainly the work ECTA was looking to have just where there was a commercial link or a commercial incentive between Trader 1 and Trader 2, that would suffice to bring click-throughs within the definition of the packages. So as I said, even though this is heralded as being the measure by which click-throughs would be brought in within the regulatory regime for the sale of packages, I think you can see from the definition that may not necessarily be the case, and it's quite easy to structure, for businesses to structure their distribution to avoid being a package, creating packages. Now, the directive also has clarified one area where there was a degree of uncertainty, and that was arising from excursions that were sold locally. And it explicitly says that if the second or additional travel service is selected and purchased after the trip has commenced, that will not render the travel arrangements a package. So that is somewhat helpful. Okay, so just to recap, you have 6 types of travel arrangements. You've got your traditional travel arrangement package that you've come across previously. You've got your what people refer to as dynamic packages, where consumers select and bundle it and pay a single price. You've got the shopping basket, which doesn't exist here in Ireland. You've got the click-throughs, which it's quite easy really to avoid structuring a package, and even if you are creating click-throughs, they may be caught under the linked travel arrangement. And then finally, insofar as if language is used to promote the sale of travel arrangements, bundle travel arrangements, that lead a consumer to believe that they're purchasing a package, again, that will bring it within the definition of a package. Okay, so moving along, we're going to look at the definition of linked travel arrangements. And this is this new beast that's been unleashed by the new Package Travel Directive. And there are essentially 2 types of linked travel arrangements. The first is where the traveller makes a single visit to a travel company, and that can be online or it can be in-store. And the travel company facilitates, and that's the language used with linked travel arrangements. It's a trader or travel company facilitating the customer, making separate selections and separate payments for each travel service. So that's the critical thing to bear in mind, that it's separate selection and separate payment. And so you have to select service 1, or the consumer is to select service 1, pay for service 1, and then move along to select service 2 and pay for service 2. And in those circumstances, you, provided you meet other requirements in relation to providing information to the customer, may create a linked travel arrangement. And I suppose the critical thing about a linked travel arrangement is that whilst there are obligations in relation to financial security, you're not an organiser of a package, you're a trader facilitating the creation of linked travel arrangements, and you do not have the liabilities that are associated with an organiser organising a package. So there's quite a degree of, there's quite an incentive for companies to think about this linked travel arrangement. But I think we'll again go on to look at the second type of linked travel arrangements. The consensus is that it's going to be quite an off-putting shopping experience for consumers, because they really must be put on notice of the fact that they aren't purchasing packages, that they're not benefiting from the protections that are afforded to consumers who are purchasing packages, and it may put consumers off. So the second type of linked travel arrangement then is where the traveller buys one travel service from one company, and then at the same travel company facilitates in a targeted manner the purchase of an additional travel service from another travel company within 24 hours. So again, Trader 1 has sold a travel service to a consumer. It's an online transaction. They send a communication to the consumer inviting them to purchase a separate travel service from another travel company, and that happens within 24 hours. So already there's quite an obvious potential for avoiding the formulation of a linked travel arrangement insofar as if that gets concluded outside of 24 hours. But again, it was envisaged that this may in some way capture the activities of particularly airlines. Insofar as you're purchasing a travel service from an airline, then you receive an email or a communication even on your confirmation inviting you to purchase another travel service from another travel company. And it just we'll have to wait and see how companies respond to these particular provisions, and will they be will they accept the constraints imposed by creating linked travel arrangements, or will they look to find a way of falling outside of the requirements of the directive? As I said, it's quite interesting for a trader to look at not creating packages and instead to be creating linked travel arrangements. But my sense is that I think the delivery of linked travel arrangements will be very cumbersome and not particularly consumer friendly. Okay, so moving on then from linked travel arrangements, we're going to have a look at the provisions in the new directive that focus on the insolvency protection requirements. And this is where we do see some changes. In the first instance, what is the same is that if you create packages and you're an organizer of a package, and additionally, if you are a trader that is facilitating linked travel arrangements, you're required to have certain security arrangements in place. And if it is packages that you're organising, the security arrangements must cover refund, and they must also cover repatriation where that is applicable. However, the big change is that the organiser's financial security it responds to their place of establishment. So it can't be limited in terms of the place of residence of the consumer, or limited in terms of the place of departure for of the travel arrangements that the consumer has purchased, or it can't be limited in terms of where the package was sold. And also the financial security arrangements that an organiser has in place they can't discriminate in terms of where the member state in which the entity in charge of the insolvency protection is located. And so the obligation is that an organiser must have financial security arrangements in place, and they must be respond to the requirements of the place in which they are established, and they must cover all travellers regardless of where they live, where their travel arrangements commence. And so that is a significant change. As regards linked travel arrangements, there's a requirement for traders facilitating linked travel arrangements to have security in place for the refund of all payments that the trader receives from travellers, insofar as a travel service which is part of the linked travel arrangement is not performed as a consequence of their insolvency. And then if it were the case that the trader facilitating the linked travel arrangement was an airline or some responsible for carriage, such as a ferry, then the trader must ensure that they have arranged, that their financial security arrangements are sufficient to also cover repatriation where that was required. So the key thing is that the trader facilitating a linked travel arrangement is only required to have financial security arrangements in place in respect of the monies that they take. So trader one, if they're selling one particular travel service, only are required to have financial security arrangements to protect the money that they take in from the consumer. And so ultimately you could end up in situations where a collapse happens with trader one, and okay, the consumer will receive a refund in respect of the travel service number one, be it the flight or whatever, but they'll be left with the second travel service that they've purchased from the second trader. And as I'm talking about the linked travel arrangements, I think you will get a sense as to how they're not necessarily palatable to consumers. And the traders, it's really important that traders inform consumers so that they understand the lesser quality level of consumer protection that they're getting when they purchase a linked travel arrangement, as opposed to when they purchase a package. Another aspect of the new directive in relation to insolvency protection is that it squarely expresses a principle that has really prevailed in European Union law for quite some time, which is mutual recognition, and that member states must recognise the insolvency protection which an organiser has provided in its member state of establishment. And so what that means is if a trader here has financial security arrangements in place for the business that it carries on, and it's not the business that it just carries on in Ireland, but it's place of establishment. And if they want to trade in France, for example, the French enforcement body must recognise the security arrangements that they have in place in Ireland. It's all to do with kind of principles of freedom of establishment and the Services Directive. Okay, so moving on then from the insolvency protection aspects of the directive, I'm just going to briefly comment on a number of aspects of the directive that are where changes have been introduced to that which was previously the case. Many of you will be aware of the fact that it's possible to change prices even after the contract has been concluded with the consumer in limited circumstances, for example, where there's a change in exchange rates, where there's a change in fuel surcharges or a change in taxes. That's up to 20 days before departure. And what the new directive says is that it's still possible to do that. However, once the price increase exceeds a threshold of 8%, in those circumstances, a consumer is entitled to look for a refund and terminate the contract. I've already touched on the weight that the new directive places on consumer information, and annexed to the directive are various notices which both organisers of packages and traders facilitating linked travel arrangements are required to provide consumers. It's somewhat similar to Regulation 261 insofar as airlines are obliged to provide consumers with information notices about the rights that they have pursuant to that particular regulation. The most critical thing, though, in relation to the notices, to my mind, is that if you do want to adopt the linked travel arrangement model, if you fail to comply with the information requirements applicable to LTAs, then the traveller automatically benefits from the entitlements that apply to consumers who've purchased packages. So the default is they become a package consumer with all the rights that are associated to that. With that. Okay, another area that the Commission have taken the opportunity to bring some clarity to is the extent of the obligations of organisers in circumstances, in unavoidable and extraordinary circumstances. And again, many of you will recall that particularly when the ash cloud unfolded, there really was a large degree of confusion amongst the sector, within the Commission and with airlines and consumers as to the obligations of organisers in circumstances where a traveller is unable to return home because of an unavoidable and extraordinary circumstance. And so the Commission has moved to, it's seeking to align the obligations of an airline with those of carriers. Now, it hasn't necessarily quite happened, but currently what the directive says is that the organiser shall bear the cost of any necessary accommodation not exceeding 3 nights per traveller in circumstances where travellers are unable to return because of UEC. So, for example, if we look at a very recent incident of UEC, which would have been the various hurricanes that have occurred, if that were the case come next year, organisers who had customers that were unable to be repatriated because of a hurricane where they're holidaying would be looking to, the consumers of those organisers could look to them to pick up 3 nights accommodation. Now, I should add that air passengers' rights in relation to looking to carriers to pick up that cost continues to exist, and whilst the air Regulation 261 is due to be reviewed, and indeed has been reviewed to quite a degree. The review hasn't got over the line because of a standoff between the UK and Spain in relation to Gibraltar. However, so as things currently stand, the airline's obligations under 261 to provide accommodation where people can't be repatriated is, as you're aware, open-ended. And within the directive, whilst it says that it's a 3-night cap, there is additional language which says that where a longer period is provided for in union passenger rights legislation, the longer period will apply. Now, when the Package Travel Directive was drafted, it was on the basis that it expected to be aligned with the new air passenger rights legislation, and we are all hopeful that it will, the passengers regulation will align it with, will fix a 3 nights accommodation, but we'll just have to wait and see how that all rolls out. It's also important to be aware that there are certain categories of customers to which the 3 nights cap will not apply. So in the case of persons with reduced mobility, persons accompanying PRMs, pregnant women, unaccompanied minors, and persons in need of specific medical assistance, the 3-night cap does not apply. Okay, then moving along, the limitation, well, there wasn't a limitation in the directive per se, in the old directive, as to the level of compensation that could be paid in cases other than personal injury. The 1995 Act, when it was implemented here in Ireland, introduced a limit of twice the cost of the holiday, so that no organiser could reduce the level of compensation for breach of contract quality issues to twice the cost of the holiday. And that has increased to 3 times the cost of the package, so you're not allowed to limit your liability to below that. And what I would say is that, in fact, Ireland was quite lucky in having the twice the cost of the holiday cap under the 95 directive, and that in many jurisdictions there's no limitation at all or no cap, and in the UK there was a cap at 3 times the cost of the holiday under their 1992 regulations. And I just want to briefly comment on the areas in which member states have a certain degree of discretion when implementing the directive. The Package Travel Directive is a maximum harmonisation measure, and that means that member states cannot go above that, what is within the directive. However, there are 2 areas in which member states do have a degree of discretion when implementing the directive. Firstly, the directive provides that organisers will be liable for the proper performance of the contract. However, it does afford member states the discretion to either maintain or introduce in their national law provisions under which the retailer is also responsible for the performance of the package. And again, just to give you a very brief bit of context in this, and I know Michelle will be very live to this because it was something we grappled with very much in the workings of the ITAA legal committee when looking at this particular provision. There are member states where it is joint liability, such as France and Portugal, and the consumer has the choice when they have an issue in relation to a package to either look to the retailer or to look to the organiser to remedy the shortcoming with the package. And those jurisdictions perceive that joint liability as in some way being an advantage, and that it is a reason why consumers choose to book with them. It's a very alien approach to particularly companies in common law jurisdictions such as Ireland and the UK, but suffice it to say they held on to it dearly. And so the compromise when the directive was being drafted was that primary responsibility would rest with the organiser, but in member states who already had the system of joint liability or member state that wanted to introduce joint liability, it's left open to those member states to do so, and it's certainly something that we will be impressing upon the department, is that we certainly would have no desire to migrate to a joint liability regime. Then the second area in which member states are afforded some discretion when implementing the directive is in relation to off-premises contracts. So these would be, for example, sales that one might make at a travel fair or something of that nature. And in those circumstances, travellers are, member states have the discretion when implementing the directive to afford travellers the right to withdraw from the package travel contract within 14 days from the date of termination. This certainly, Brian, would be something you'd be familiar with in insurance contracts, that it's consumers are generally afforded cooling off periods. They have a reprieve, or traders have a reprieve in the travel sector against the majority of the entitlements of consumers to terminate at the end of cooling off periods. But this is an area where member states have been given some degree of discretion. Okay, so that's, as I said, very much a whistle-stop tour through the core provisions of the directive. Just a little bit of information about what the ITAA has been doing. We have conducted 5 sessions of a PTD working group. It's a focus group of about 8 members, where we have taken each chapter of the directive and gone into it in an in-depth fashion. And it has been very useful for me to do that with members, so to get their input and feedback as to the difficulties they identify in adapting to the requirements of the directive and identifying ways in which the ITAA can help members adapt to the requirements of the directive. And so, just to give you a flavour of what we are looking at working on in the coming months, evidently we'll be monitoring the implementation. And just a brief word on implementation, which is that at this point in time, I had to look at the legislative programme for 2018, and there was near a sign of the Package Travel Directive. That said, I suppose it's always possible that it could be fast-tracked. And one thing that I would caution is that, to a certain extent, because there's so little scope for member states to exercise discretion when they're implementing the directive, it's going to be very much a copy and paste vis-a-vis the vast bulk of the directive. And again, I was looking at the Department of Biz in the UK. They've issued they're embarking on a consultation in relation to the implementation of the Package Travel Directive, and they've recognised that by and large most of the directive will it'll be straightforward copy and paste in terms of implementing it in the UK. But in any case, we will be monitoring the implementation process. Revisions will have to be made to the current package terms and conditions, and also new terms and conditions will have to be prepared for linked travel arrangements. Assistance will have to be provided in relation to the formulation of general agreements, though I don't think that they will be quite so straightforward. I think they'll be more bespoke, depending on the different types of businesses. And then finally, we will be looking at preparing guidance notes in relation to the information notices that traders will be required to provide to businesses. And you'll be relieved to hear that I have nothing further to add. Suffices to say that if any of you have, obviously we'll have a question and answer session here, but if any of you have questions in relation to the directive, or indeed the Payment Services Directive, don't hesitate in contacting me. Thank you.